So I would like to get started and call the meeting of the Education and Wellness Committee to order and ask for Ms. Hawkinson to please take roll.
Ms. Yoslowski?
Present.
Ms. Pines?
Present.
Dr. Krause?
Present.
Ms. Shitsky?
Thank you. I want to welcome you all to the Education and Wellness Committee. I'm Barbara Yoslowski, chair of this committee. And I would like to remind you all to please turn off your cell phones, please turn them to silent and make sure they're off the table. Also, everyone with Blackberries, please make sure your Blackberries are off the table so we can avoid feedback noises. You may also notice some of the committee members accessing their laptops. For this meeting, it's solely to access committee meeting materials, and because they are in the electronic format. This is an official business meeting of the Medical Board of California, and as such, disruptions to the board's business will not be accepted. We've designated time on the agenda for public comment on items not on the agenda, and we also ask for public comment on each of these agenda items. Should anyone not be able to adhere to these rules, we will have to deal with that. The meeting will be available via teleconference, and individuals listening to the meeting will be able to have an opportunity to ask questions or be participatory in the discussion. And we will be assisted by a moderator of the phones over there in this side of the room. And please wait until the moderator has introduced you before you make your comments. And to request to make a comment during the public comment period, please press *1. You'll hear a tone indicating that you are in a queue for comment. If you change your mind or do not want to make a comment, press this number key. Assistance is available throughout the teleconference meeting. To request a specialist, please press 0. The committee welcomes public comment on any item on the agenda. It is the committee's intent to ask for public comment prior to the committee taking actions on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or identify yourself on the phone and you will be recognized. I would like to remind all speakers physically present to complete a presenter's slip. There should be in the back of the room, and to hand it into Ms. Hawkinson, who is here at the head table. You put your hand, that's who she is. And for those on the phone, please provide your name and any organization you represent. Each person will be limited to 3 minutes per agenda item. However, during the agenda item 3, public comments on the items not on the agenda, the committee has limited the public comment period to individuals on the teleconference to 20 minutes. In addition, public comments from individuals here at the meeting will be limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During the public comment on any other item on the agenda, 10 minutes will be allowed for comments from individuals on the teleconference line and those as well in the audience. Armando Melendez will be assisting me with the public comments via the teleconference line. He's over in this corner. So we're going to move on to item number 2, on public comments on items not on the agenda. Do we have any comment slips? Do we have any hands in the air? Do we have any comments from anyone on the phone line? We'll wait and find out a second.
Do we have any comments on the phone now? There's no one from the phone yet.
No one's online.
Okay, thank you. So we're going to move on the agenda and the approval of the minutes from the July 24th Education and Wellness Committee.
So moved.
So I have a second?
Second.
Do you have any public comments on approval of the minutes? Do you have any comments from the phone line for approval or questions on the minutes?
Do we have any public comment?
My understanding is we have to do a roll call on
Correct.
items that are moved for approval. So would you, to that end, take a roll, please?
Yes, with regards to approval of the minutes, Ms. Yoslowski?
Approved.
Ms. Pines?
Approved.
Dr. Krause?
Approved.
Approved unanimous.
Thank you. Moving on to number 4. Foreshadowing things to come, I guess. I'm going to ask for a presentation on the corporate practice of medicine from Ms. Carrie Webb and Ms. Diane Dobbs and Mr. Ian McClone. And my apologies for any mispronunciations on your names.
Good morning, or good afternoon, board members. My name is Ian McGlone. Just by way of introduction, I have been an employee of the board for about 8 years. Among other duties, for the past 5 years, I have been processing any complaints or handling any questions that deal with corporate practice of medicine concerns or violations. Today, we're going to go over some to try to give you a background about corporate practice. We have some goals for this presentation for you today. We want to make sure that you can answer some questions by the end of this presentation. To start off with, we want to go over what is corporate practice and what precisely is banned by corporate practice. Also, to understand why it is banned. And then we're going to go over some red flags that physicians should look for that may indicate that the corporate practice of medicine is involved with the practice. And then finally, we want to go over what the consequences may be for a physician who is aiding and abetting in the illegal corporate practice of medicine. So the basis of this prohibition on the illegal corporate practice of medicine is found in the California Business and Professions Code. The foundational code is Section 2052, which talks about prohibiting any person from practicing medicine in this state without a valid certificate or license. So that's blanket, that applies to person or any kind of entity. Now, when we move on and look at California Business and Professions Code Section 2400, this is where it specifically indicates that corporations and other artificial legal entities shall have no professional rights, privileges, or powers. So a corporation or a business in California can't practice medicine, can't get a license to practice. And looking at these two sections together, specifically what is prohibited under Section 2052, these are lists of types of activities that require licensure. And when we look at 2400 together with 2052, it becomes very clear that you cannot have an artificial entity that practices or attempts to practice a system of mode of treating the sick, etc., that can't diagnose, can't prescribe. I'm not going to read through this whole list here, but it is in your materials too if you want to review it in more detail. But the punchline here is that a corporation or other artificial entity may not practice medicine. It would be engaging in the practice of medicine if it engages in any of those activities that are prohibited by Section 2052. And that's because in Section 2400, as we mentioned, the artificial entity has no professional rights, privileges, or powers. I do want to take a moment just to highlight, though, that while corporations have no professional rights or powers under the Medical Practice Act, this prohibition is not absolute. There are some very limited exceptions. Physicians may quite obviously practice in partnership with other physicians. That's a business entity. As we will explore further later in this presentation, physicians may practice under a professional medical corporation that is properly formulated and run under California law. And there are further other specific limited exceptions to this ban on the corporate practice of medicine that we're not going to get into in any great detail. But just to highlight them, they allow, like Section 2401 of the California Business and Professions Code, allows for certain clinics, narcotic treatment programs, and hospitals to charge for professional services and or employ physicians. However, it should be stressed that in all cases, these artificial entities shall not interfere with, control, or otherwise direct the professional judgment of a physician and surgeon. So while there are exceptions, the fundamental theme here is that physicians have to be in charge of their own practices. So getting right to the next question, we kind of understand what corporate practice of medicine is now and what is banned, but why do we ban it? We want to make sure that the patients are protected in California. That is one of the fundamental roles of the medical board and of the Business and the Medical Practice Act. We want to protect the patients to make sure that unqualified persons, i.e. unlicensed persons, are not making or influencing medical decisions in any way. And we want to reduce the chance of divided loyalties. We don't want to have a physician have to make a choice between keeping his or her job and serving a patient properly, providing appropriate medical care within the standard. Again here, undue influence and interference with the physician's judgment. This is all kind of variations on the same theme. We want to make sure the physicians are the ones in charge of the practice. Sometimes when I'm talking to someone on the phone, I like to use the analogy of, driving a car or captaining a ship. The doctor can hire other people. If the doctor is the captain of a ship, there can be a first mate or an engineer that does things at the physician's behest. But the physician is the expert. The physician is the one in control of the entire practice, if the medical practice is a ship. On this next slide here, we just have some more information, or another reason for banning the corporate practice of medicine, which is coming from a quotation from an Attorney General opinion, and it just eloquently states what we've been talking about. The presence of a corporate entity is incongruous in the workings of a professional regulatory licensing scheme, which is based on personal qualification, responsibility, and sanction. So here again, we're summing up why it is important to ban the corporate practice of medicine. This ban protects consumers of medicine. It makes sure that the decision makers in medical situations are those who have expertise, have the knowledge necessary to practice safely. Also, they're those that have the ethical obligation to make sure the patient is treated well and properly, and that no harm is done. And finally, it's so that these individuals can be accountable to the board. Since these individuals have licenses, if they breach the standard in some way, if they violate the law, we have a way to hold them accountable. It's not quite so easy if a layperson were to be in charge. On the next couple slides, on this slide right here, we have some examples of things that a physician must do and that an entity or a layperson may not be in charge of. Again, these are diagnostic tests, determining which tests are appropriate, determining the need for referrals to specialists. One thing I would like to highlight that's not on these slides is that this includes procedures such as Botox or laser treatments. Just because a procedure may be elective doesn't mean it's appropriate for a layperson to have any control over whether or not it can be done or is necessary. So we're going to move on, and I'm going to hand it over to Ms. Webb.
Thanks, Ian. So sometimes when we talk about the corporate practice of medicine, question comes up, how do you know when you're in trouble? How do you know that you need to rethink the arrangement you have gotten yourself into? And so there are some telltale signs that we've identified as red flags, and one of them is that if the physician doesn't have control over the patient records and it's a management services agreement entity, that's a problem. If a management services company is telling a physician what kind of things should go into a record, maybe given support for a certain type of care, certain types of tests, certain types of procedures, that's also a problem. If the unlicensed individuals are telling physicians who they should hire and whether a certain provider should be fired, that's a problem. Physicians should be making decisions about equipments and testing and who gets hired. what kind of advertising is done, those types of things. And again, that's easy to say, but you also have to know how to recognize problems on the paper, which these contracts can be multiple pages long, lots of fine print, and there are some things that may stand out as being obvious and some things that are less obvious. So this is from a management services agreement that I took a look at, and there were multiple problems with it, but I've highlighted some things that I think a physician should recognize as a red flag. In this instance, the PC that's identified as a professional corporation. That is a corporation that was created by physicians, and it's a legal arrangement that Ms. Dobbs will comment upon later. So the PC is the professional corporation. The company is the management services organization, and this is the agreement that they wanted to enter into with a professional corporation, the doctors. So what I have underlined here is that the company can terminate the agreement if the professional corporation fails within 30 days after receiving the written notice from the company to remove from the center any provider, any doctor, who the company determines has materially disrupted or interfered with the performance of its obligations hereunder. The company is also down under section 4.2. It says the professional corporation shall provide services under normal business hours as established in consultation with and subject to the approval of the company. The physicians set their hours. The physicians determine how much time they're going to spend with a patient, not this management services organization. The professional corporation, the physicians themselves determine which providers should be terminated, not this lay corporation. Another clue is proprietary rights. So this is a management services agreement that they tried to make some corrections to indicate that the company makes these decisions on equipment and advertising and hiring, but that it's all subject to the physician's approval. But then in another section, it says all works, discoveries, and developments which are at any time conceived or reduced to practice by the professional corporation and or any of its providers shall be the property of the company. So again, who is really in charge? These are things to be alert to. I think those examples are more blatant than this next one, but again, when you see that in this management services agreement, the company was taking care of all these things: client scheduling protocol design, client service and complaint handling, clinic management analysis. It's really hard to tell from these lines what that means and what the company will have control over versus what the physician will have control over. And this requires some probing, and I would like to see clarification as to what these things actually mean. Client scheduling protocol design could mean that the management services organization is setting the schedule. It requires more probing to make sure that as a physician you're not running afoul of the ban on the corporate practice of medicine and aiding and abetting, which will come up a little bit later. So, unfortunately, and I'm falling behind here. I got so into it. Even if a franchise arrangement, it has to be run through the Department of Business Oversight, and they take a look at franchise agreements, they take a look at these management services agreement, even if somehow it gets approved through the Department of Business Oversight, it doesn't mean that a physician's involvement is legal. Even if a corporation is registered with the Secretary of State, that doesn't mean a physician's involvement is legal. Just because a management services agreement appears to say all the right things on paper, a lot of times there's some clue that will tell us who is really in charge. And again, a lot of times if you go to proprietary rights, that tells you a lot. This is saying that the practice, so here's an agreement where, sometimes they refer to the PC, which is the professional corporation, talking about the doctors, and this one, they're talking about the practice, which is the providers, the doctors, recognizes that all records, files, reports, protocols, policies, manuals, etc., and other documents used by the company in rendering services or relating to the operations belong to and shall remain the property of the company. And again, this is one where the doctors purportedly had input on all the policies and procedures. A lay company doesn't have business retaining medical records. So this is a clue that even though they're trying to say all the right things to get it through scrutiny, when you get down to proprietary rights, it's telling you that the lay company is really in charge of what's going on here. With that, I will turn it over to Ms. Dobbs' portion.
Okay, so to reiterate, even if all the paperwork says all the right things, it's really important to focus on the actual practice, what's actually being done in the office. What's, how is the office practices being carried out? If a complaint is filed, the investigation it'll definitely look at the paperwork, but it'll also look very closely at how the practices are actually done, how the business is being conducted. So we talked about some of the prohibited structures. You cannot have a non-physician owning or operating a business that offers evaluation of patients, diagnosis, care, or any kind of treatment. So any operation that purports to do that would be illegal. Similarly, physicians operating a medical practice as a limited liability company is prohibited. Limited liability partnerships are prohibited. And of course, general corporations are prohibited. Management services, as Ms. Webb pointed out earlier, management services organizations can't arrange for or do the advertising for a physician's medical practice. And of course, they can't provide any of the medical services. They are limited to providing administrative services. And so the physician must control the practice. And so even if the physician has all the controls, if any of these things are being done by the management services, then you have a problem. Similarly, physicians acting as medical directors for non-physician owned operations like medi-spas is a problem. That actually would be aiding and abetting the unlicensed practice of medicine if they are providing any kind of medical services, non-physicians. So moving on, we'll ask, how will the medical board ever find out about these things? How do we get wind of these? And a lot of times it comes by way of an injured patient, a dissatisfied patient. Advertisement often provide wonderful clues as to what's really going on and who is really in charge. Other state agencies sometimes provide a report to the medical board. Competitors, disgruntled partners that a doctor may be in business with, ex-employees. But there are many ways that these come to the board's attention. So let me try and provide a few tips to avoid some of the pitfalls that Ms. Webb pointed out. Know the traps, some of which Ms. Webb has pointed out to you. If an entity is going to take care of everything, there's a problem. If it's too good to be true, it usually is. The thing to remember here is that a physician has to be in charge of all patient care issues, all referrals for the patient. Any decision that goes into the care of the patient, a physician has to be in charge. So if somebody is going to take care of it, then that should be a red flag, a big red flag, that you're somehow allowing someone to practice who is not authorized to do so. Another thing is know your resources. There are several resources out there, one of which is the medical board's website. And if a physician really wants to know about all the basics of what's prohibited regarding the corporate practice of medicine, a simple search on the board's website will bring up many articles and many other resources. So know the resources. Another good resource is the Attorney General's website. On that site, you can search opinions, and if an opinion has been offered on corporate practice and what kinds of practice have been found to be illegal in the past, that's another really good resources. Similarly, statutes and case laws, and of course, disciplinary decisions from the medical board are also really good resources. Another tip that we'd like to offer is do not allow the attorney of the other entity to provide you with assurance that the arrangement is legal. It really is the physician's responsibility to make sure that all the T's are crossed and all the I's are dotted, and that they are fully in control, and that everything that they're having someone else do, that person is legally allowed to do it. That is a good tip to avoid getting into trouble. So how can physicians operate legally in a corporate structure? Ian pointed out earlier that it is possible, and yes, there are some exceptions. So the first is comply with the Moscone-Knox Professional Corporations Act in setting up the corporation. So the corporation must be set up correctly in accordance with this law. The next is to make sure that the makeup of the medical corporation is at least 51% physician-owned and no more than 49% of the list of other healthcare professionals noted in Corporations Code Section 13401.5. It lists other professions that can be a part of a medical corporation, and it really is limited to those. But the thing to remember here is that the makeup has to be at least 51% physician-owned. The next thing to remember is if you're going to use a fictitious business name, that you comply with all the requirements of sections 2285 and 2415. So we're saying all of this to basically remind you that there are consequences, and serious consequences, for violations of the corporate practice ban. Aiding and abetting is probably one of the most severe consequences for physicians. And that comes with civil and criminal penalties, and of course can result in administrative actions against the physician's license for unprofessional conduct. Are there any questions for any of us?
Dr. Krause?
I have a general question. It would appear that the ban on corporate practice is intended to protect patients, intended to assure that in their relationship with their physician, that their physician is not under any kind of coercive arrangement that might cause them to withhold care, or even in certain circumstances potentially advise care for a corporation's economic interest that may not be necessary. Yet nonetheless, physicians are still in other types of coercive arrangements as providers of insurance companies. And insurance companies will make decisions about medical necessity and what's covered and what's not covered. Is there any case law where that has been looked at as potentially in violation of corporate practice?
I'm not aware of anything that specifically addressed that, but I can understand your point. It is one of the things that physicians must be aware of, is that, you know, if someone tells the physician this can't happen, and the physician knows that this is what is absolutely in the patient's best interest, then they do have a responsibility to fight for that. How successful they'll be, you know, of course, I'm sure there are varied results there.
Yeah, actually,
I'm not aware of any case law.
Most physicians do fight for it. It's called prior authorizations. It's called sitting on the phone waiting to speak to a nurse to have approval for an MRI. It's called fighting for a medication that you feel better serves your patient. And we expect our physicians to continue doing that. But I sometimes wonder if hidden within there may be a violation of corporate practice, but I'm afraid I'm going to have to leave that up to the attorneys and the courts.
Yes. Yeah, unfortunately, oftentimes we, you know, have to wait for guidance from, you know, a case that has gone up the chain, so.
Yeah, and you're probably aware there are all sorts of appeal processes that have to be followed, and Department of Managed Healthcare gets involved and makes decisions, but it's a whole different section of law when we start getting into insurance coverage and different ball game. But it's a great question.
What has our experience been regarding disciplinary action on this matter? How many complaints do we receive? How many cases do we look at on the ban on corporate practice?
Are those numbers that you have?
I don't have any numbers, so anything I would say would be an estimate. I just want to preface that. As far as disciplinary actions go, I can't speak to that because I do not process the discipline that would result. I do process the complaints that come in, and I mean, is it even appropriate to give an estimate without hard numbers?
That's something that we can report back. There is a presidential decision, Stein-Smith. The California courts have been firm in supporting the ban on the corporate practice in California. And there are numerous cases. You know, for example, you had a presentation on the co-location of the registered dispensing opticians and the optometrists. That has implications involving the corporate arrangement and potentially undue influence of the licensed providers' decisions. There's a recent case, it's a marijuana clinic case involving, the name is Cardio, I believe, where the unlicensed individuals were contracting with a physician, and the unlicensed individuals were making the decisions on timing, how many patients were being seen and for how long, and just the physician purportedly was making the medical decisions, but everything else was being done by these lay individuals. And the court said, no, it's a violation because they had too much control. It wasn't just administrative functions. It was involving the entire practice. And so again and again and again, the California courts have said this isn't appropriate.
To continue along the road where Dr. Krause was going, are there opportunities by which the Department of Corporations or Managed Healthcare is involved or engaged with the medical board if we're disciplining or bringing to attention to the doctors of what is and what isn't appropriate behavior as far as the corporate practice of medicine? When this is occurring or when it's being found to occur, the person that has either the business license to operate the entity or the insurance company that is promoting the ability to manage or direct care, do those cases go forward with any kind of collaboration with the medical board? Or
yeah, the Department of Business Oversight from time to time sends me these agreements because they sense something's wrong and want confirmation. But you have private corporate attorneys that are working on these agreements and making assurances to other agencies that everything is correct. But again, when someone over there catches something that they identify as potentially problematic, then they send it our way.
So we discipline the license of the doctor who is participating in inappropriate behavior. The question I basically have also, though, is there any kind of public knowledge? Shouldn't the public be aware of companies that are doing this as well? I mean, it just doesn't, it feels like we're taking and doing our due diligence. We're trying to educate the doctors of what they can and can't do. We discipline the license when they're not doing appropriate things. But be it the insurance company, be it the entity, the private business entity that's employing doctors, are they also, is there a structure by which they are also being informed and disciplined? Maybe that's are you aware that this is working, and just not our half of the situation, but the rest of the situation?
Well, if we find unlicensed practice, of course, the folks that are practicing without license will be, they have consequences. There are civil and criminal consequences there.
So the physician can be disciplined for unprofessional conduct for aiding and abetting, and the unlicensed folks can be subject to fines for the unlicensed practice and criminal penalties.
Okay, so that's.
But you were asking in terms of education to
Right.
these non-physicians.
So, for example, when someone takes out a fictitious, when they take out a license to do business, at that point of the discussion, within the formatting of the application, with the receiving of the application, the business is applied for. Is there some kind of review at that point? Is there some kind of information at that point so that the person is well aware of the fact that they can't do business for a doctor? Is there a way to start the process earlier so that we don't get to the point where discipline is what the outcome is?
Yes, the samples that you have in here are at the beginning of the review process for the Department of Business Oversight. And so before it ever got approved,
Someone's looked at it in some government entity and
Right.
made sure that
But-
the formatting of the application is appropriate.
at least in these ones. So I can't speak to every franchise arrangement that goes through. That's why part of the warning is just because it's been approved, it doesn't mean that the arrangement is legal. But on some ones where there are obvious problems, I've had some input on.
Ms. Kirchmeier?
And I think, Ms. Yaroslavsky, one other thing that we really wanted to do is we wanted to bring this as an educational piece here in your committee, but then the fallout from this is that we really want to get these slides on our website, and I think what you've just said is a great alternative, an addition to that education is when we get fictitious name permit applications, when we send information back to them, we can send them these slides. I think these slides would be very helpful to them in addition to the law, so I think that's a great educational tool, and I think that's a great recommendation.
That's where I was going with that, as far as our part of the
Right.
portion is. But it's also when people are going and taking out business licenses within the city that they live, or the county that they live, or the area that they need to receive an application from. At that point also, if there would be some kind of recommendation that we could make as part of our recommendation online for our applicants, that there should be something before it ever happens, that people should know when they're filling out that application under the penalty of death, of being, disciplined, that the facts that the statement is true. That I know there will always be in the world people that are trying to do things for the wrong reason or the right reason, but if we could try and attempt to figure out a way that people taking out business license, fictitious business license, or any kind of things are in fact doing what they're purporting to do under the rule of law.
And that's another thing we could look to, too, is with business oversight, getting the information to them, so when they come to them to apply to them, giving them that information, and also going to the local county areas and identifying who hands them out, and then being able to educate them as well, and so they can pass it on. They're not going to be able to answer the questions, but they can hand out the information at least.
Thank you. Ms. Bunz, did you have any questions? Dr. Krause?
In the last year or two, I'm aware of a medical group that entered an agreement, I think, with CVS to provide medical supervision for nurses that work in their walk-in clinics. Mm-hmm. When a medical group enters that type of contractual arrangement, do they have an obligation to assure that in the nurse's employment that there isn't any corporate coercion in terms of what to prescribe? Or is the medical group shielded from that by simply supervising the nurse?
It was a program that first came to the medical board before they were bought out by CVS, by which those issues were raised. And where it came before us was the idea of where a doctor was involved as far as the oversight of the staff at the pharmacy. At that point, we were admonished that there would be no oversight as to which medications were being prescribed, that they would be available or not available by that pharmacy, but that the doctor would be available with either a phone call or in person within a specific time frame. So those issues were definitely raised at that time, prior to CVS buying out the entity. And it definitely was a concern, but it definitely, they made presentations and those questions were offered and the answers received, so that it seemed to be totally separate. They were independent nurse practitioners.
Excellent. I assume that the ban on the corporate practice has been a recent subject in our newsletter, and if not, perhaps it warrants an update. I know that there will be information available on the website, but I don't think that most physicians look at the website unless they're stimulated to do so by a problem or by something that's seen in the newsletter. But thank you very much for this presentation.
You're welcome.
Thank you again. Thank you, Dr. Krause. Good point. So, Ms. Hawkinson, we're going to move on to the your office strategic plan update, please.
How would you like to proceed? Would you like me to go through each thing? I know that, or would you like me to just kind of elaborate?
Our time is, we have the time, I think. So
Yeah, okay.
let's go.
Okay. The first goal we're going to look at is basically identifying opportunities for placement of articles on mandatory reporting in our professional newsletter and other publications. In the summer newsletter, we had an article from Los Angeles Coroner on the need for physicians to sign death certificates. We also had an article on the importance of physicians reporting pesticide poisoning to the local health departments and the protocol to file a report. Board staff is completing an article for the coroners to include in their newsletter on the need for a coroner to report to the medical board pursuant to Business and Professions Code section 802.5. I have one thing I want to point out, and it kind of doesn't specifically fit in here, but it doesn't really specifically fit in any of these, but we recently did an article in our fall newsletter on the Soldiers Project. A former board member, Linda Lex, had drawn our attention to this project, and we staff wrote a really nice article, and it was requested by the psychology board if they could reproduce that article in their newsletter and their website, and so we gave them permission to do that. And so that's kind of what's going on with that particular area. Are there any questions? Go ahead.
No, I just wanted to suggest that as we go through this and as we get to the end of it, that as you see that there should be an annual review of every year. We should have an article reminding coroners to report. Every year we should have an article reminding about the corporate practice of medicine. We should try and identify and prioritize those so we realize what we can look forward to over the year as well. I think that might be an opportunity as well, just as in your mind.
Gotcha.
Catalog.
Okay. Conduct outreach on reporting requirements to all mandated reporters as resources allow. We have quite a bit here. In April of 2014, staff discussed mandatory reporting requirements involving hospitals and physicians with the San Bernardino Sun and LA Daily News. On May 8th, a presentation was provided to the California Association of Medical Staff Services in Sacramento, addressing mandatory reporting requirements, specifically focusing on the Business and Professions Code sections 805 and 805.01, reporting process and requirements. Approximately 100 individuals were in attendance at that particular event. In June 13th of 2014, staff had a conference call with the staff from Public Citizen to discuss the peer review process and reporting requirements. August 1st, 2014, presentation was provided to the California Association of Medical Staff Services in Riverside, addressing the Business and Professions Code sections 805 and 805.01 reporting process. On the 28th of August, a presentation was given to the Rancho Los Amigos Rehabilitation Hospital on the reporting requirements of Business and Professions Code 805. And on November 7th of 2014, a presentation was given to the Los Angeles County Department of Health Services Quality Improvement and Patient Safety Program on Business and Professions Code 805 and 801.
So let me ask you a question. As a result of those kinds of discussions and those kinds of presentations, were you able to garner that there were any increase in articles or any increase in reports back to you? I mean, are you going to be able to track whether these visits or these presentations were able to result in any kind of return on the dollar? So to speak?
Well, a lot of these are done by enforcement, obviously, because they're the people that go out and do a lot of this, and a lot of investigators as well. Absolutely. I mean, I think we see that when we work with the different agencies as a whole, that they understand what their reporting requirements are. As far as tracking it, I don't know what type of tracking you would be looking for, other than the fact that we address these groups, we explain the law, we explain the requirements, and you know what they should be looking at, what they should expect, and then obviously the feedback's always very positive. We've had situations where we've asked, different organizations have asked if they could post our presentations on their website, which we've definitely given permission to do. And to me, that's a sign that, you know, this is important to them, this has been valuable information for them, and they want to share it.
Okay.
Continue. Next, we have engaged in 2 or more consumer outreach events with area organizations as travel permits. There's a lot of this. Would you like me to go through each of them?
Do you want to have her go through it, or you want to?
I reviewed them,
Right.
and I'm most impressed with the amount of outreach and work that's being done. But I don't know that it needs to be relisted at this meeting.
I don't think it needs to be read. No.
I have some additions that I'd like to just briefly point out that didn't make it yet, because they are new additions. On Thursday the 12th, we have another town hall in Folsom, California, for consumers. On Friday, January 23rd, I actually attended a presentation, a town hall with Assemblywoman Susan Bonilla in Walnut Creek, which was very successful and generated an article in the Mercury News. And I really enjoyed that. I feel like there were about 150 people there, and at that time I also talked with Assemblywoman Bonilla about, you know, possibly a health fair or a health-related town hall, which her and her staff were very interested in. On the 20th of February, we'll be attending another presentation on another town hall in Citrus Heights. On March 4th, I will be, again, making a presentation to the Consumer Health class at California State University, Sacramento. That's a long-standing gig that I do for Professor John Tamlin. That has been incredibly successful and rewarding, I think, for all parties involved. Also, we are planning a prescription drug awareness campaign to coincide with March being Prescription Drug Awareness Month. And I've been working with the National Coalition of Prescription Drug Awareness, and also California Department of Public Health, and other consumer agencies that I'm talking with. I've recently got contacted by another one that's local. And what we're hoping to do is bring awareness. There's a 5K walk that's going on in San Ramon, and there's going to be a health fair that we are going to be participating in and contributing to. And I think that, you know, working together with them, especially given the fact that we have the new prescribing guidelines, and this is a very serious issue, and we have the work group that we're doing with public health and other agencies, that, you know, it's time to work with these groups to get that word out and to unite with a united message to move forward on this. So those are some of the things that are coming up that didn't make it.
That's great.
It's great.
Thank you. Continue to provide articles and information in the newsletter regarding potential violations to assist physicians in understanding the laws and regulations. The summer newsletter had an article on recommending marijuana and things physicians should know. They also had an article in the summer newsletter regarding the inadvertent unlicensed practice of medicine by postgraduate training individuals. The summer newsletter had an article on what to know about signing death certificates. Our fall newsletter had an article entitled "Do Not Panic, what you should expect if a complaint is filed against you. Now, this was part one of a two-part series. The second part will be coming out in our winter newsletter. In the fall newsletter, there was an article on POLST, Physicians' Orders for Life-Sustaining Treatment, from the Coalition of Compassionate Care of California. The winter newsletter, as I mentioned, will have an article on fictitious name permits, in addition to part two of the Do Not Panic article, which will discuss what happens during the investigation and disciplinary process. So we're taking that to fruition, next step up. Launch a Twitter account, done. Our Twitter handle is MedBoard of Cal, and we sent out our first tweet on January 14th announcing the release of the annual report. It was retweeted and picked up. We've had some other people retweet it. In addition, we tweeted last night inviting people to attend this particular meeting. And in fact, it was picked up by the Ebola group with 96,000 followers and was retweeted. So that's 96,000 people that received that tweet and a retweet. We also this morning tweeted out that we had our board meetings and that they were available, that they were open to the public. In addition to this afternoon, we've tweeted out that we are live and you can watch us on our website. So we've launched it and we've got a protocol set up and we're going to be moving forward. Any questions?
No? Any questions? Any questions?
And I think it's all very impressive. I appreciate it.
Thank you very much. Okay, we have examine opportunities for the board to provide training to licensees via the internet. And we'll start with work with DCA to establish webinar protocol and the tools needed to hold successful webinars. As I introduced earlier, our new public information officer will be focused on identifying needed webinars and training, and we'll be moving forward with this objective. We actually recently set up an editing room with software and the ability to record in there and that type of thing. So this is the next big step that we plan on taking forward. Work with healthcare agencies and organizations regarding topics of interest for training purposes. The board, as I mentioned a little bit ago, is a key partner with the California Department of Public Health regarding the statewide work group that seeks to curb prescription drug misuse and abuse. Additional plans for this campaign are in discussion. As we mentioned, with regards to Prescription Drug Awareness Month in March, we plan on doing the activities and that type of thing. And this work group meets on a regular basis with a lot of ideas and a lot of suggestions, and is very active. It involves a number of different agencies, including the Dental Board and the Pharmacy Board, Department of Education, California Department of Managed Health Care. Anybody that's a stakeholder has been invited to attend these. As you may or may not know, the governor's office has asked that the state come out with a united front and message with regards to this problem, since it's such an issue for California. And so this continues, this group continues, and we look forward to continue to work with them. Expand and continue to cultivate relationships with various ethnic communities through their individual media outlets by providing information and education on the board's roles and responsibilities. Town hall meetings that we've discussed are key to developing this. In April 2014, board staff, including a Spanish-speaking investigator, assisted Telemundo with a multi-part series on consumer protection for the Hispanic community. The board has established a good working relationship with Telemundo. In fact, we recently had another one of our enforcement people do an interview with them on how to file what happens with enforcement and what they need to do, and it even addressed how to file a complaint. We continue to work with them very closely. The neat thing about the town halls is, the one thing I found that was really fascinating when I attended in Citrus Heights for Assemblyman Cooley, there was a group there that was of Afghani and Iraqi refugees, which I thought was really interesting, and made a connection with them, and look forward to trying to reach out to their community because they actually have a fairly new community and continue to add to it. So that was a connection that I made there that I found incredibly fascinating. Engage in television and radio interviews, promoting transparency and providing needed information as requested. Staff has been and continues to work with the San Jose Mercury News regarding an issue involving psychotropic drugs in foster kids, which I'm sure the committee's familiar with. Worked very closely with Karen Dessa with regards to her articles and this particular series. In addition, the Department of Investigation is working closely with KPIX and CBS in the Bay Area regarding a news story focused on the investigative process specific to a certain issue that I can't talk about, but they're working on that. And this is done on a daily basis with both California National Media.
You need to wrap it up.
Okay. PSAs, as you know, we have the 3 PSAs that are out. I'm still looking to get those broadcasted on network television, and so I'm working on that. We're working on a video to be placed on the board's website explaining how to file a complaint, in addition to how to look up your physician. As you know, we have a video on there right now for licensing, for new licensing students to follow on how to fill out to apply for a California medical license. Board staff will continue to expand with regards to groups and areas where we can continue to speak and continue to move out. We put a notification in our newsletter inviting people to let us know if they would like us to speak, and we're more than happy to come and do so. Let's see, I don't think really, the only last thing I want to point out is providing presentations on the board's roles, responsibilities, and mandatory reporting requirements and processes at hospitals and health systems. In June of 2014 and October 29th of 2014, board staff met with UC schools and UC regents representatives to discuss graduate medical education issues and overall application licensing issues. And on November 6th, Laura Sweet and board member Dr. Lewis gave a presentation entitled Discipline, Drugs, and Duties to Nurses and Physicians in San Diego at the 2014 Multidisciplinary Correctional Healthcare Conference.
Thank you.
There's other things, but...
So if anyone else has any questions, let them, let them continue reading, and they should probably check in with you during the meeting. Is that okay?
Oh, absolutely.
Something else that you wanted just to highlight, because I'm trying to get it so that the next committee could start.
I do want to highlight one other thing that we did on September 19th of 2014. With a grant received from the Federation of State Medical Boards, the board held a 3-hour free CME seminar course in Los Angeles at the Hilton LAX on safe prescribing, titled Extended Release and Long-Acting Opiate Analgesic Risk Evaluation and Mitigation Strategy. That's the only other thing I really want to make sure I pointed out to you.
Thank you.
Okay.
Any public comment?
Any public comments on the Ms. Hawkinson's report? Anybody on the phone with any comments?
From the phone, if you do have a question or comment, press star and 1, and I will open your line. Okay, we have a question or a comment from Michelle Montserrat Ramos. She's with the California for Patient Rights. Go ahead, please.
Good afternoon. My name is Michelle Montserrat Ramos. I'm calling in from Los Angeles. We are pleased to see that you finally launched your public Twitter account. I know I had asked early on when you planned on an account launch to communicate with licensees. So we are pleased you have launched an account for the public. Comments. Your NBC Twitter handle, it wasn't easily locatable. If you could try to outreach to groups so stakeholders will know this account exists. If you could tweet press releases, release via email alerts so the public will know you are taking some disciplinary action against doctors putting California patients at risk. If you would tweet other email alerts out to the public so we know what work enforcement is doing. If you would tweet how the public can sign up for email alerts so the public is aware of the work you are doing. I realize that the PIO mentioned that she had tweeted or staff had tweeted of the meeting today last night. If you could tweet maybe at least 3 days ahead of time so the public is aware that you're holding the meeting where they can participate in person or via teleconference. And if you'd attach the agendas with that, give the instructions on how to participate via teleconference. And regarding 3.3, providing training, item D, conduct webinars to promote public protection. Will you please invite the public and tweet about it? Thank you.
Thank you very much. Any other comments? So do members of the committee have any suggestions for agenda items for future discussion?
Yes.
Yes, please, Dr. Krause.
At some meeting this year, I think we need to reapproach the potential for a physician health program. And I would suggest that perhaps we could ask staff to garner information and report at one of our meetings the spectrum of physician health programs that exist in other states, so we can begin to work on that problem.
Okay, thank you. Anything else? Okay, so we'll leave it open, and people have suggestions or ideas, they should speak directly with the executive director. Is there any public comment on suggestions for agenda items? Any phone recommendations? So I'm going to move that we have adjournment. Do you have? I did ask, I thought. That was an ask. That wasn't an answer, but it was an ask.
From the phone, we have no comment.
Thank you. So I'll entertain a motion for adjournment, please.
So move.
Thank you. A second? We'll move on, and meeting is adjourned, and we'll start the next meeting in 5